Have you ever helped someone do something? You knew what they planned to do, you showed up, you handed them the tools, and then later tried to say, hey, that wasn't me, that was them.
Oh, I've definitely been the person who said, I'm just driving. I don't know what they're doing in the back seat.
Right. And a court would look at you and say, you knew, you drove them there, you helped.
That's basically what we're talking about today in Cisco Systems versus Doe I.
Welcome back to the High Court Report. Today, an American tech giant, a Chinese surveillance system, a religious minority subjected to torture, and two federal laws that might hold Cisco accountable for all of it.
Or might not. That's the whole fight. We'll get clarity soon. The Supreme Court hears oral arguments in this case on April 28th.
Quick reminder before we go further. Please follow, rate, subscribe, share, and review the podcast on Apple, Spotify, YouTube, anywhere you podcast. Just search the High Court Report. And honestly, given that this episode involves surveillance, Cisco's lawyers would probably prefer you not share it, but please do anyway.
Questions about this case? Reach out to us via LinkedIn at the High Court Report.
All right, here's what you need to know. Here's the two questions the court must answer. First, does a 1789 law called the Alien Tort Statute, a TS for short, allow courts to create a civil lawsuit for aiding and abetting violations of international law? Second, does a 1992 law called the Torture Victim Protection Act, the TVPA, authorize the same kind of lawsuit?
Okay, let's slow down because aiding and abetting violations of international law sounds like something out of a law school exam.
Fair. Here's the plain version. The ATS, passed by the very first Congress in 1789, gives federal courts the power to hear lawsuits by foreign citizens for violations of international law, things like piracy, torture, crimes against humanity. But the ATS doesn't say who can sue whom. It just opens the courthouse door. Courts have been filling in the details ever since.
And the TVPA, that's from 1992, actually creates a specific lawsuit. It says, if you, acting under the authority of a foreign government, subject someone to torture or extrajudicial killing, which means an unlawful killing outside a real court process, you owe that victim damages. The key word in both statutes. Does any of this cover someone who helped the torturer? Not the torturer themselves, but the company that built the system the torturer used to find victims?
That's exactly the question, and it's actually two questions wrapped together, which is why the court took this case.
Let's work through the facts. Respondents, 12 Chinese nationals and 1 American citizen, all practitioners of Falun Gong, filed this lawsuit in 2011. Falun Gong. Let's give some context. It spread rapidly across China in the 1990s, growing to roughly 100 million believers. Its teaching center on truthfulness, compassion, and tolerance. Believers committed to nonviolence. In 1999, the Chinese Communist Party declared Falun Gong a threat and launched a campaign to force believers to renounce their faith. The CCP called it duzheng, violent struggle, beatings, electric batons, arbitrary detention, re-education camps. The State Department estimated hundreds of thousands of believers suffered persecution. Credible reports put the death toll in the thousands.
And here's where Cisco enters the picture. To implement this crackdown at scale, the CCP needed something it didn't have: sophisticated internet surveillance technology. Falun Gong believers used the internet as part of their faith, visiting specific websites, downloading and sharing religious material. The CCP needed to cast a wide net over China's entire internet.
So the CCP reached out to Silicon Valley, including Cisco, and said, build us a national surveillance system, and the most important goal is cracking down on Falun Gong.
Cisco answered that call, according to the complaint. Cisco's CEO, John Chambers, personally met with China's president and promised CCP officials to support the crackdown. Cisco's internal documents used the CCP's own term, Duzheng Falun Gong, and described the Golden Shield project as a lucrative business opportunity.
The Golden Shield. That's what they called it. Cisco engineers in San Jose designed what the court described as first-of-their-kind features, early machine learning algorithms that detected Falun Gong internet activity, cataloged users, and sent real-time alerts to Chinese security. Cisco also built databases compiling home addresses, financial records, family contacts, IP addresses. Those databases fed directly into Chinese detention centers.
And during torture sessions, interrogators opened those files. Jane Doe the First's torturers referenced Golden Shield data, while beating her with an electric baton. John Doe IV's interrogators brought up his emails while pouring ice water on his body. Officers questioned Mr. Wang about his wife's whereabouts using data Cisco compiled.
The complaint estimates thousands of Falun Gong believers got identified, arrested, and tortured using Cisco's technology. And respondents say none of this could have occurred without Cisco. Cisco pushes back hard on all of this. Cisco says it sold only standard, off-the-shelf networking equipment, in full compliance with U.S. export regulations, and it did not customize any of it for the Chinese government. This case arrived at the Supreme Court on a motion to dismiss, meaning no jury has ever heard the facts, and Cisco has never had the chance to test those allegations at trial.
The district court threw the case out in 2014. The Ninth Circuit reversed in 2023 in a divided opinion, finding aiding and abetting claims viable under both statutes. 7 judges dissented from the denial of a full court rehearing. The Supreme Court granted certiorari on January 9, 2026, and now it's at the Supreme Court.
Let's get into the arguments. Cisco, that's the side asking the court to reverse, leads with the biggest argument first. Forget aiding and abetting. Forget Cisco specifically. Federal court, Cisco argues, lost the authority to create any new causes of action under the ATS, period. Full stop.
Wait, how? Courts do that all the time, don't they?
They used to. The ATS itself creates no causes of action. It just grants jurisdiction. Back in 2004, the Supreme Court decided Sosa versus Alvarez-Machain and said, okay, courts can theoretically recognize a narrow class of new ATS claims, but proceed with great caution. In the 20 years since, the court has tightened the screws in case after case. In Egbert versus Boole, that's from 2022, the court said creating a cause of action is a legislative endeavor, full stop. Congress does that. Courts don't.
And Cisco says, once you apply that logic to the ATS, no new claims ever survive. There will always be a reason to defer to Congress, especially because foreign policy concerns are inherent in any ATS case. Cisco points out that in over 230 years of ATS litigation, only 6 cases resulted in collected money judgments, out of approximately 300 filed. The court has repeatedly tried to shut the door. Cisco says, shut it completely, now.
But even if courts retain some residual authority, Cisco's second argument, aiding and abetting, falls outside it. Here's why. In 1994, the Supreme Court decided Central Bank of Denver versus First Interstate Bank of Denver, a securities fraud case, and established a rule: civil aiding and abetting liability does not exist unless Congress expressly provides for it. Statutory silence means no.
And the ATS, one sentence, jurisdiction only. Not a word about aiding and abetting, not a word about who can sue whom. Cisco says central bank controls, and that's the end of it. The Falun Gong practitioners, the respondents, come back hard on every one of those points. On the founding era history, aiding and abetting violations of the 3 original Law of Nations torts, piracy, offenses against ambassadors, violations of safe conducts, itself violated the Law of Nations at the founding. William Blackstone, the leading legal authority the founders relied on, said all accessories to piracy shared liability. Attorney General William Bradford said in 1795, with no doubt, that ATS suits could target Americans who aided and abetted attacks in Sierra Leone.
And respondents draw the modern analogy. After World War II, American and Allied tribunals prosecuted corporate enablers of Nazi atrocities. Bruno Tesch, owner of a pesticide company, supplied Zyklon B gas to SS death camps, knowing exactly what it would do. A British military tribunal convicted him and executed him. Respondents argue Cisco occupies the same role. A corporate actor that knowingly supplied the tools of systematic persecution.
On central bank, respondents say Cisco misreads it. Central bank applied normal statutory interpretation to a specific securities provision and found aiding and abetting lacking in that context. It created no blanket rule. The ATS uses the word tort, which in 1789 covered any wrong and injury, and aiding and abetting violations of international law itself constituted a violation at the founding. Every single federal circuit court that addressed this question found ATS aiding and abetting liability available. Congress never acted to eliminate that consensus.
Here's where it gets interesting on the TVPA. Cisco argues the statute's verb, subjects, cannot mean aids and abets. Cisco offers a plain language example. A parent grounds a child. the parent subjects that child to punishment. The neighbor who complained about the child, prompting the parent's anger, did not subject the child to anything. The neighbor enabled the punishment. But subject requires more than that.
Respondents flip that argument. They say subjects means to expose or render liable to, intentionally broad, intentionally different from commits, which Congress used in criminal torture statutes. Congress chose a bigger verb for the TVPA because it wanted broader reach, and the Senate Judiciary Committee said explicitly that TVPA liability extends to those who ordered, abetted, or assisted in the torture.
The United States government filed an amicus brief. That's a friend of the court filing, supporting Cisco. Both parties agree the government's voice matters here. The United States argued that SOSA's barely open door to new ATS claims should close entirely. They compared SOSA's theoretical exception to a doctrine the court declared moribund in a 2021 case called Edwards versus Vanoy, a rule that existed on paper but never operated in practice. The government said the same fate should befall ATS common law expansion.
The government also flagged a practical point. When Congress wanted civil aiding and abetting liability for terrorism cases under a different statute, the Anti-Terrorism Act, it added the words aids and abets explicitly in 2016. If Congress wanted the same under the TVPA, it would have said so. It didn't.
So those are the stakes. What does this actually mean for real people?
If Cisco wins, if the court rules no aiding and abetting liability exists under either statute, the immediate effect, this case ends. The Falun Gong practitioners get no day in court, no trial, no chance to confront Cisco's denial that it customized the technology.
The broader effect. American companies that do business with foreign governments, sell technology into authoritarian states, or participate in global supply chains face dramatically lower legal exposure for their customers' human rights violations. The political branches, Congress and the President, would hold the exclusive levers for accountability.
And critics would say, that leaves a gaping hole. Systematic atrocity requires infrastructure. Without civil accountability for corporate enablers, companies face no legal deterrent from building surveillance systems for authoritarian governments.
If the Falun Gong practitioners win, if the court affirms aiding and abetting liability under the ATS and the TVPA, Cisco faces a trial. More broadly, American companies doing business with foreign governments that commit human rights abuses face civil exposure in U.S. courts. Global supply chains, technology exports, financial services, all of it suddenly carries legal risk tied to the customer's conduct.
And proponents say, that's the point. You don't get to build the machine and wash your hands. The ATS existed specifically to make the United States a place where the law of nations gets enforced, not a haven for those who help break it.
The fault line at oral arguments, watch for the justices to press Cisco on where the line falls. If courts cannot imply any new ATS causes of action at all, not aiding and abetting, not anything, then SOSA itself needs to go, or at least its core holding about courts recognizing modern international law claims.
And watch for questions about the TVPA's subject's language. The government and Cisco both accept that command responsibility, where a superior officer orders torture, works under the TVPA. Justices will push, if a commander who orders torture without touching the victim counts, why doesn't a company that built the system use to find and detain the victim? The separation of powers tension runs through everything. Several justices will likely press the government side. Does the executive branch's position here reflect a policy judgment? Don't embarrass China? More than a legal one?
Bottom line time. Why does this case matter?
Because it draws the line between corporate accountability and judicial overreach in human rights litigation. If the court shuts the door entirely, American companies get clarity, and American courts get out of the foreign policy business. If the court keeps it open, companies that knowingly supply the tools of atrocity face civil liability in U.S. courts.
And behind all the doctrine, there are real people who say Cisco built the system that let Chinese security forces find them, arrest them, and torture them. The Supreme Court will decide whether U.S. courts even get to hear that claim. We'll cover the opinion the moment it drops. If you made it this far, share this episode with one person who thinks the Supreme Court only matters when it touches Roe or the Second Amendment. Because corporate liability for surveillance technology sold to authoritarian governments affects everyone.
You can find us on Apple Podcasts, Spotify, YouTube. Just search the High Court Report. Please follow, rate, subscribe, share, and review on every platform you use. Follow on LinkedIn too. If Cisco's Golden Shield could track Falun Gong believers across all of China's internet, surely you can find one podcast across 2 apps. Questions about this case? Reach out via LinkedIn at the High Court Report. We read every message. Talk to you soon.